to say something about the Limitation Act. This is an act to curtail the remedy and not the right. It bars the remedy alone. The previous act was in 1908, and this was replaced by this act 1963. The limitation period prescribed in the previous act, for example, was 60 years in case of possessions, mortgage, etc. This act reduced the period to 60 years, to 30 years, just with an intention to speed up the right to be enforced. Now, what is limitation? Limitation, just a bare meaning of it, means some restriction, some type of restriction. That is, a person is not given a free hand. An enormous freedom enjoyed is restricted. That is, a right to be enforced within a particular time. Say, for example, we can say it as a time limit. If there is a time limit, we are bound to take action, initiate some process within that time. This is a limitation. This Limitation Act contains around 31 sections. Each section has its own measures, like fixing some limitation, extending limitation, giving new period of time, giving a provision for certain type of disabilities, holidays, etc. This act contains a schedule. This schedule prescribes the time limit within which the proceeding had to be initiated. This schedule contains 3 columns. That is, the description, that is the nature of the proceeding, whether it is a suit or an appeal or an application. This Limitation Act deals only with 3 things. That is, with respect to suits, appeals, and applications. That is all. All proceedings are brought into this 3 broad categories. These 3 broad categories are formulated into a schedule. This schedule contains 3 specific columns. That is, description of the proceeding, either it is a suit or an appeal or an application. It fixes a period of limitation. And the 3rd column says about when the time starts. That is, what is the time limit and from when the period starts and before which time the suit had to be filed, or an appeal had to be filed, or an application had to be filed. This is the broad category. Now, it also says about different types of suits. We have around 10 types of limitation prescribed for different types of suits. And appeals, of course. Appeal may be higher judiciary or in subordinate judiciary. The time period may vary. And for application. Just to remember it very, very easily, let me just connect you with some ideas. If we are filing a suit, maximum it is always related to years, number of years. Limitation period is always expressed in terms of years, say 3 years, 12 years, 1 year, etc. If it is appeals, then it is always mentioned in days or in months. See, for example, 30 days. Appeal from subordinate judiciary, subcourt to district courts. Or we can say it as also 1 month. Appeal to High Court, 90 days or 3 months. So we can remember it easily. If we relate to suits, we can relate it to years. In case of appeals, we can relate it to days or months. In case of applications, it combines both. It also contains days. It ranges from days to years. So this is the pattern with which we can easily remember, and we shall go into the limitation law, keeping this in mind. Now, this limitation, as I said, it restricts some right. It restricts some right. That is, a period beyond which a person cannot claim a remedy. There is, of course, the right is not extinguished, but remedy alone is barred. How would I say? See, we can relate it to a very, very simple example. We will take the case of a promissory. Yeah, all of us know 3 years is the limitation time period from the date of when it accrues. That is, if it is a demand promissory note, it accrues on that very day itself. 3 years time is prescribed. Now, beyond 3 years, the person, that is the plaintiff, cannot sue. It creates a fetter. It creates a bar. But can we say the remedy itself is lost? If the defendant comes and if the borrower comes and pays on the 5th year, he feels guilty of that debt because debt never dies. He feels guilty, he comes to you and tenders the money. Will you say, no, the limitation period is completed, it is over, so that I don't want them? No, you are going to take the money. So the right to that money is not barred, but the remedy through process of court, process of law is barred. That is why I am emphasizing the right is not barred, whereas the remedy is barred. This is for the plaintiffs. When we see it for the defendant, the defense is not barred. Limitation Act bars right to the plaintiff, but does not bar defense to the defendant. Even if he does not take it as a defense, then the period of limitation prescribed under the Act will act against the plaintiff. Section 3. That we will go to. So, the point of the Limitation Act is fixing a time limit beyond which the plaintiff cannot demand. He cannot demand as a matter of right. He cannot enforce that remedy. 2, his demand is barred by law. And 3, the defendant can pay at any time, and that is not restricted. Now, what is the principle behind it? It says, law will help those who are vigilant. That is, within that particular time limit, you must have to act. It is not thinking, it is acting. You think to file suit, but does not file suit, that will not give you the right. You must have to act. Where there is a right, there is a remedy. You must have to enforce that right within the time available to you. So only then you can enforce that remedy. You have to exercise that right. Now, that right should be exercised within that period of time, within the limitation period of time, within the limited period of time, within the restricted period of time, within the given period of time. If you wish to enforce that right beyond that period of time, then that is barred. Even 1 day is barred. You file a suit after 1 day, beyond that 3 years time prescribed, even that 1 day is barred. So it says the person must be vigilant. Law helps those who are vigilant and not the one who is sleeping. Vigilantibus non dormantibus principle will apply. This is the legal maxim. 2 legal maxims apply. The law, this limitation is prescribed in the interest of all. In the interest of the state, there must be an end to litigation. Even this principle, we can relate it with res judicata. If one case is decided, then it is deemed to be decided fully. Of course, if it is decided on merits, the exceptions we need not discuss it now. So, in the interest of state, there must be an end to litigation. A person should not re-litigate the issue, res judicata. Second time litigation is not possible. So, this principle, interest republica at sit finis litium. So, this principle applies both to Limitation Act as well as to res judicata under CPC. Now, where it applies? To all disputes regarding property, money dealings, contracts, easementary rights, movable or immovable property, anything. So, whenever you have a remedy, you can enforce it under this law. So, the object of the act is to regulate the time period. See, there cannot be an endless time for anything. There should be some period of time within which a person has to come. See, we are boarding a train. Within that time, we have to board the train. Every act has its own limitations. Now, with this, a small preview about the limitation. That is, we have now discussed about what is limitation, the object of limitation, why it is necessary, and the tables contained, that is the schedules. But how are these schedules, what we saw earlier, are enforced? All this, the all are regulated, these 30 sections. This Limitation Act applies only to three things. One is for suits, another one was for appeals, and the third one is for applications. Simple. We apply this Limitation Act only to suits, appeals, and applications. That is all the Limitation Act deals with. So I hope this Limitation Act will be easy for us to learn. Now, what does this Limitation Act say? What are all these 30 sections say? It says bar of suits, one aspect. Two, it deals as to the court before which you have to file the suit. It means proper court. You cannot present the suit in some other court just for the purpose of convenience, just for the purpose of making it know that you have filed the suit. Now, what this act gives privileges, some leverages, some concessions. It gives concessions on holidays, vacations. If suppose a person wants to file the suit, but he could not file the suit because of some legal disability. Example, a minor. Minor, however, he is mentally mature, he is barred from filing the suit by himself. It is a disability. What will happen if there are three minors, one after the other in a family, if father died? So, what is the continuing disability, one after the other? What is the right based on a contract? All these things apply for suits, apply for appeals, apply for applications. Two, how are we going to compute the limitation? For everything, there is a calculation. How are we going to compute? How the time limit starts running, where it is interrupted, where it is excluded, where it does not run at all, or where it runs every time. Example, tort. All these things we will see. Acknowledgement of liability. A fresh period starts. Other aspects like continuous breach, If suppose the instrument mentions a time, a particular time, from which the cause of action starts, accrues, then the limitation will start from that period. What is with respect to possessions, adverse possession, easement rewrite? This area is dealt under sections 25, 26, and 27. That we will discuss. Now we will march into the various sections of the Act. If you have the Limitation Act in hand, it will be very helpful for you to refer to various sections, because we are now attempting to learn all the provisions one after the other. Rereading will always help every one of us. Now, important provision is section 3. This is the fundamental section which court always takes into account. It has a duty to comply with section 3. Even if a person files the suit beyond time, the court has to see whether the suit is filed within time. Suppose, assume for a moment, you file a suit after 5 years with respect to a claim for money. The defendant also does not take any defense like that. No, the suit is not, suit is barred by limitation. What is the situation? Section 3 bars that remedy automatically. Even if the defendant does not take that defense, the law of limitation automatically applies, and the court can remove that file suit out of its file. Section 3 captions saying bar of limitation. This limitation for suits, appeals, as well as for applications. But the section 3 places an emphasis on suits, because why I am saying is section 5 is applicable to appeals and applications. Section 5 is not applicable to suits. We cannot plead sufficient cause for suits. Condonation of delay for suits is not possible. See, it says, subject to the provisions contained in section 4 to 24. That is, section 4 to 24 are exceptions to section 3. Every suit instituted, appeal, preferred, and application made after the prescribed period shall be dismissed. Shall be dismissed, although limitation has not been set up as a defense. Although limitation has not been set up as a defense. Even if the defendant does not set up the limitation as a defense, then the suit just it files by itself. So now, what is a suit that we have? That when is the suit to be filed? Where it should be filed? Section 3, subsection 2 says that the suit should be filed in the proper court. Of course, there is always a possibility of a mistake. It must be, generally, it must be filed in the proper court before the proper officer. Suppose you file a suit in the municipal court instead of filing it in the sub court. That is not a proper filing. You have to get that return and then file it. Suppose if you want to file a suit in a particular court, but whereas files the suit out of jurisdiction elsewhere in some other district, that is also improper filing. Of course, certain leverages are given in the Act. We can always take the return. We can relate it to Order 7 Rule 10 CPC. Take the return and file it in the proper court. The time between the filing and return, that is from the date of return till representation, are excluded. If the court specifies some time, no, You have filed the suit in the wrong court. Okay, you take that return and file it before proper court within 3 weeks. Then you have to comply that condition. So that is the privilege given to the plaintiff if he has missed out to file it in the proper form. Now, in case of a pauper, what happens? Pauper suits are preceded by a pauper application. Automatically, suit is not filed. An application is filed seeking leave of the court, permitting him to file the suit as a pauper. If that application takes 2 years' time for disposal, then that 2 years are excluded. That we will see it in the forthcoming sections. Just I am indicating it. So pauper can file a suit within time. Case of companies, they can file a suit within time. And what happens to set off and counterclaim? For plaintiff, he has to file a complaint. Suppose the defendant says, if you are asking for 1 lakh rupee, defendant says, no, I am only liable to pay 30,000 rupees, 70,000 had to be set off. Then what is the limitation? 2, there is always a possibility if the defendant claims 2 lakhs, that is over and above the plaintiff claim made by the plaintiff. That is counter claim. The plaintiff makes a claim, whereas the defendant makes a claim over and above the plaintiff's claim. That is counter claim. What is the limitation for that? In case of set off, the limitation is on the same day as the suit in which the set off is pleaded. It is the same day as the suit. But whereas for a counterclaim, it is the date on which the counterclaim is made into court. See the distinction. If it is filed as a set off, then we can take it as the date of presentation as the date of plaint. In case of a counterclaim, then the date has to be calculated on the date of filing of the counterclaim. 2 different dates given for the same defendant who is going to seek different reliefs. In case of any application filed before High Court for notice of motion, then the day on which it is presented before the court. So this is with respect to section 3. As I said, section 3 applies to suits, appeals, and applications. It says when the time starts. That is, the time starts when the plaint is presented before the proper officer. In case of pauper suits, in case of companies, set off, counterclaim, and applications. This is section 3. I just wish to point out some case laws in this. Case laws are 1. 2020 1 CTC 2020 1 CTC page 38. 2020 1 CTC page 38. Division bench. That is, the court is duty bound to check limitation. If suppose the court has missed to see it, the defendant can always file an application to reject the plaint. Order 7, Rule 11 application. If the plaint is barred by law for the time being in force, that is Limitation Act, then an application can be filed to reject the plaint. 2. AR 1997 Supreme Court, AIR 1997 Supreme Court 2724. AIR 1997 Supreme Court 2724. Same duty of the court to seek relief. If there is any disability, then the plaintiff must have to give proper explanation. Okay, what happens to arbitrations? Limitation Act will apply. Section 3 of the Limitation Act will apply. Inbuilt section under the Arbitration Act, Section 43 will apply. Take case law for this. 2020 4 CTC 216. 2020 4 CTC 216. This says a claim, arbitration claim, cannot be entertained beyond the limitation. If there is a breach of contract, then arbitration proceeding must have to be commenced within 3 years. Else it is barred. Another case law says that this particular principle, if allowed, that is, if an arbitration proceeding is allowed to be filed, to be conducted beyond 3 years, it is violative of public policy. 2020 4 CTC 2020 4 CTC 299. 2020 4 CTC 299. So the cumulative effect of this section is section 3, if it is applied, even a defense is not made, the court has its inbuilt duty to remove the suit from on file. This applies to EPs also. Suppose of a foreign decree, if it is filed later, it has not been filed within period of time, then it has to be rejected. Even EP, it applies to applications also. 2020 2 CTC 2020 2 CTC 877, Supreme Court. 2020 2 CTC 877. Bank of Baroda versus Kotak Mahindra Bank. Here, the EP wants to the EP was filed after 14 years. They said nothing doing. Section 3 will apply, it is to be automatically rejected. So with this, let us move into the exceptions to section 3. That is 4 to 24. 4 to 24. Exceptions. What are all the exceptions? What happens if you are coming to the court on the last day, which was a Sunday? What happens? We cannot file the case on Sunday. So, Saturday or Sunday, if the court declared holidays or public holidays, it can be filed on the next day. It can be filed on the next day. That is on a Monday. AR 1997 Madras. AIR 1997 Madras 308. What it says is, it does not extend limitation. It provides for contingency. There is a contingency, an emergency, a situation. The court excludes that time. Next, 2010 2 CTC 109. 2010 2 CTC 109, Supreme Court. 2010 2 CTC 109. If it is a public holiday on a Sunday, then suit can be filed on the next day or on the immediate day. Vacations, suit can be filed on the reopening day. Section 4 gives this privilege, this allowance. Now, Section 5. Section 5 deals with sufficient cause. Sufficient cause is nothing but a reason, an acceptable reason to be given for the delay. See, now I wish to point out, Section 5 is applicable only for appeals and applications and not for suits. You cannot file a suit with a delay and file under Section 5. It is applicable only for applications and appeals. Now, extension of prescribed period in certain cases. Any appeal or application other than those provided under Order 21 may be admitted if there is a sufficient cause. So appeal or applications other than Order 21 may be admitted if there is a sufficient cause. Now, what are all these sufficient causes? Not well, jaundice, as we usually plead under Section 5. Death, sudden death in the family, could not file the application within time. Loss of documents, summons misplaced, arrest, if a person is in confinement, cannot appear before court, or if there is some mistake, counsel's mistake, reasonable mistake, acceptable mistake, all these things, etc., come under sufficient cause. Now, if we read Section 2L, Definition. Suit does not include an appeal or an application. Suit does not include an appeal or an application. Now, if we see section 5, it says any appeal or an application shall be filed beyond that period if provided we give sufficient cause. So we have to see it section 2L and section 5. Now, it contains some explanations. In suits, what happens if a person, if the defendant is at ex parte and an ex parte degree is drawn, 30 days time period is also missed out, section 5 comes into force. With that section 5, he can file an application to seeking an opportunity for him to be heard. If he files one application under Order 9 Rule 13, that is to set aside the ex parte degree, and also challenges by way of an appeal. Section 96 appeal is a statutory appeal, a regular first appeal. If he invokes 2 remedies, what happens? Even if an application under Order 9, that is section 5, is dismissed, he can always challenge it under section 96. If suppose section 96 appeal is dismissed, then the application filed under section 9, read with Order 9 Rule 13, fails automatically. That is the explanation under section 5. Now, AR 2000, Delhi 336, division bench. AIR 2000, Delhi 336. That is, section 5 will not apply for suits. Court cannot grant leverage on equitable grounds. Next. 2001, AIR 2001 Supreme Court, 2497. AIR 2001 Supreme Court 2497. That is, the court which conducts the proceedings under section 5, it has a discretion to do substantial justice. If sufficient cause is explained, it can invoke its discretion to grant the defendant the time and an opportunity to contest his case, his defense, place his defense. 2019 5 CTC 351. 2019 5 CTC 351. 2019 5 CTC 351. This is what I said. That is, statutory remedy under section 96 can always be invoked. First appeal, remedy under first appeal can always be invoked, irrespective of an application under section 5. Next, 3-member bench. It is also in same terms. 2020 recent judgment, 2020 1 CTC, 2020 1 CTC 377. 2020 1 CTC 343. 2021 CTC 343. 343 is the 3-member bench and 377 is the single judge. Now, what happens? This judgment will be very important. 2009 6 SCC, 2009 6 SCC 194. 2009 6 SCC 194. It says section 5 application is mandated. Why I am saying this? See, if the defendant does not come to court on a particular day, he is set ex parte. Now 30 days time is granted for him to file an application to set aside the ex parte degree. This is one issue. This is with respect to his explanation for the day on which he did not come. That is, if it is posted on 5/11. On 5/11 he could not come, which he can explain it on within that 30 days time, move an application. Suppose if he does not come within that time and another 3 months goes, he must have to give explanation for that 3 months. So now on that day he could not come. That is one issue. For this 3 months extra time, he could not come. So there are 2 things now. Order 9 Rule 13, sufficient cause. It contains the word sufficient cause in Order 9 Rule 13. You can say, you can explain. You can explain On the day you could not come. But
சார்
for section 5,
இண்டிவிஜுவல்னா அவர் கொஞ்சம் எடுப்பார் சார் அவரு.
for section 5, you must
இண்டிவிஜுவல்னா
have
என்ன
explained the
ஸ்கொயர் ஃபீட்
period
என்ன பிரைசிங் சார் அது?
not continuing with the schedule.
சரி.
Now, this is, so section 5 is mandate 2009 6 SEC 194. Now, if suppose the court finds that there is no sufficient cause, what happens? The court has no other go except to dismiss the application. It finds that. If it finds that there is no sufficient cause, can it give? No. It cannot exercise that type of discretion. 2008 5 CTC 663. 2008 5 CTC 663. Supreme Court. Now, what happens for delay in representations? Delay in representations have to be treated as if there arose a delay in presentation of the application. 2007 4 MLJ 635. 2007 4 MLJ 635. See, in all these cases, in one another case, just you can have a note of it. 2003 SEC 554. 2003 SEC 54. That is, sufficient cause is an elastic expression. You cannot confine it to a particular thing. See the circumstances and then take a decision. It's an elastic expression. You cannot confine it to, it cannot be a rigid rule. Now, what happens? There are umpteen number of decisions in section 5. We cannot note everything. I have quoted certain judgments in different directions. With this, I wish to go to section 6. Section 6 is with respect to disability. Disability. That is, a person could not file the case. He wanted to file the case, but he could not. Example, minor. Legal disability. Legal disability. He is prevented from filing the case because he does not have that competence to file the case. Legal disability. Can be a minor or an idiot if it is an insane person. Of course, they can file the case through some other person. In case of a minor, guardian. In case of others, by next friend. Section 6. What happens if there are two disabilities? That is simple. One disability after another. He is a minor, becomes an insane after some time. He is not competent to file. So, each of the period runs. If one disability is over and if the second disability runs within that period, then an allowance is given. What happens if there is a break? Then you cannot call it a disability. The time starts. So section 6.1 says legal disability 1. Section 6.2 says if there are continuing disabilities, two disabilities one after the other, leverage allowance is given to exhaust both the disabilities. If the disability continues till death, what happens? If a person is insane till death, he cannot act by himself. Then legal heirs can act. Legal heirs can file. What if it happens for the legal heir is also insane? The next person, the another person, his legal heir can file. So it contains various sub-provisions, subsections, 6.1 to 6.5. Disability includes a person who is a minor. A minor includes the person who is in the womb. See, 18 years he is disabled from filing the suit. What happens? Either he has to file the suit through a guardian. If he does not have a guardian to represent, he is neglected, then he has to wait. He has to file the suit. If a guardian is a wrongdoer, what happens? He believes the guardian is a wrongdoer. Trustee, he does not act. In that case, it is automatically he is disabled. So this disability is protected by law. 2020 1 CTC 68. 2020 1 CTC 68. See, minor can question the sale after 3 years of his majority. Within 3 years of his majority. The minor is minor. Once he becomes major, this disability ceases, and 3 years time is granted to him to question the sale. Following this, that is 2001 3 CTC, 2001 3 CTC 316. Supreme Court, 2001 3 CTC 316. What if happens if there are several disability of several persons, one after the other? Example, father dies, leaving 3-4 minor children. Of course, each one have to become major. If the first son becomes major and he does not question the sale, if he is entitled to give a valid discharge, and if he does not do that, what happens? I'll just narrate you with one case law. 2016 6 SCC 725. 2016 6 SCC 725. See, in this case, mother, widow, sells the ancestral property in 1982 without the permission of court. She sells it. First plaintiff, he comes at the age of 20, he files the suit. A defense is taken, no, other plaintiffs are aged around 25, 26 and all. Therefore, he alone cannot now file the suit. The court said all of them, those plaintiffs are female members. At that time, they did not have they cannot give a valid discharge. So the court said this plaintiff who, after attaining majority, he files the suit, his suit can be entertained. The another plaintiff who is following him was still a minor. Other plaintiffs are majors, but they are not competent enough to discharge, give a valid discharge. That is, accepting the sale. These female members who were not co-partners, they cannot give a valid discharge. So in that case, somewhere around 5 to 6 years was saved for this plaintiff who immediately after attaining majority files the suit. Now, this is section 6 and 7. Certain times, let us now travel to section 9. Continuous running of time. Once the time starts, then it continuously runs. That is the law. It doesn't stop. It says no subsequent disability. No subsequent disability will help the plaintiff, will protect the plaintiff. But certain exceptions are there. Suppose if a person writes a will, then on his death, the will comes into force. He appoints an executor. In that case, executor has to go before the court and take some of the permission as directed in the will. In that case, that time period is excluded. It doesn't run. That time spent for obtaining the letter of administration has to be excluded. Section 9. So even though there is a continuous running of time, that particular time is excluded. In case a trustee, section 10, suit against the trustees. No time limit to file suit against person against the property vested in trust. Section 9, section 10, section 6, section 7, 8, all these things just gives some concessions. That is, even if the time started, all those times are stopped or stalled for a particular period till the disability or some inability ceases. Now, we will go into the second part of the Limitation Act. How you compute the time? All these sections says about filing of the applications within some time, or if we could not file, some time limit is granted, some concessions are there. How will you calculate the time? This is again divided into three parts. Exclusion of the time, extending of time, and the limitation continues and it does not stop. These three stages. Section 9, 12, 13, 14, 15 deals about exclusion of time. It excludes. For example, see, you are applying for a certified copy. The time period taken in the certified copy is excluded. It's exclusion of time. Pauper files an application as a pauper and he gets the permission only after 1 year. That period is excluded, exclusion of time. Filing the suit in the wrong form and prosecuting it good faith. That period must be excluded, exclusion of time. Other aspects, if there is a stay order, that is an exclusion of time. See, if a suit has to be filed by government only after obtaining some sanctions, some orders, prosecutions, exclusion of time. Now, what is extension of time? Extension of time is dealt under section 16 to 21. The extension of time. There is a time, it is extended. How? Example, fraud or mistake. It doesn't know there was some fraud. You get to know the fraud only now. Even though the time would have started. But till that fraud is discovered, that period of time is excluded. That is extended. Sorry, limitation is extended. Concealment of certain things. Time limit is extended. Acknowledgement of liability. 3 வருஷத்துல payment தரணும். On the third year, just 2 days before, if a payment is made or any acknowledgement is made, the time limit is extended. So 3 years, another 3 years, 6 years, it is extended. So this is extension of limitation. Now, continuity. Limitation doesn't stop at all in certain cases. Tort, it doesn't stop. Everyday breach. If there is a decree for injunction, it continues. Not to disturb peaceful possession, it continues. So you cannot say that the decree has been passed within 3 years you should have filed a suit against me. It continues. The breach continues. Now, we'll just see it one by one quickly. Section 12. Section 12 applies for suits, appeals, and applications. First day is excluded. When it is to be filed, that is the day is to be excluded. In case of appeals, revisions, reviews, the certificate copy taken, the time taken for obtaining the certificate copy are excluded. 1961, AIR 1961, Supreme Court, AIR 1961, Supreme Court 832, 1961, Supreme Court 832. Then AIR 1967, AIR 1967, 1470. 1470. Time obtained for arbitration award, that is excluded. Now, another section 30. This also deals about exclusion of time. That is, the time period in that particular portion of time is excluded. Pauper. That is what I said earlier. Now I am quoting the section 13. In case of paupers, pauper suit. Wrong jurisdiction, section 40. A time limit is excluded. Case laws. AIR 2000 Supreme Court. AIR 2000 Supreme Court 2023. AIR 2000 Supreme Court 2023. Section 14 says about court. But any authority having the trappings of civil court is included. 2024 CTC, 2024 CTC 616. 2024 CTC 616, that is taking the suit and filing it in the proper forum for representation, or section 34 application if it is filed before some other court, that those time is excluded. Now, another judgment 2020 2 CTC 805. See, in this case, what happened is interestingly 2020 2 CTC 805. The person files in the correct court for one relief, and he allows the suit to be dismissed for default. Then he pleads that he wanted to file in the correct court, in the another court. He says that he wants to file in the correct court. The previous suit filed was in the correct court. So he cannot ask for exclusion of the time spent in that court. He prosecutes the suit for 5 years, from 1989 to 1994. So there the court said, no, you have already filed the suit in the right court. Now you cannot take it and represent it in the wrong court. I mean, that is we cannot condone the delay. Now, exclusion in other cases, that is stay order, sanction of government permission. AIR 1984, AIR 1984, 1383, AIR 1984, 1383. That is stay order time is excluded. EP filed by receiver, that is till he is appointed as receiver, that time is excluded. For auction purchaser, if an auction purchaser, after purchasing the property, he wants to take possession of the property, within that time limit, within that time, an application has been filed to set aside that sale, then that time is excluded. If the defendant is outside India, that time is excluded. All these provisions relate to exclusion of time. Now, section 17, effect of fraud or mistake. If there is a fraud, somebody, defendant committed fraud, we do not know. Concealment of document, we do not know. The time limit starts from when the fraud is discovered or mistake is discovered. If the judgment debtor has prevented by fraud, if the judgment debtor has prevented the plaintiff from executing the decree practicing fraud, then that time is excluded. 17. 2001 7 SEC, 2001 7 SEC 549, 2001 7 SEC 549. Now we shall see section 18, acknowledgement in writing. We will encounter this issue every now and then. This is with respect to promissory notes or any suit relating to making a claim for money. One aspect we have to take note of it is the acknowledgement must be made in writing before the time limit. Suppose 3 years time is over, the person gives in writing or he makes an endorsement in the promissory note saying that I am acknowledging the liability, then that is sufficient, even without payment. On the rear side of the promissory note, it is yes, acknowledged. Fresh limitation period starts. Section 18. Another 3 years time, but condition is that it must be in writing and it must be signed. AIR 1999 Supreme Court. AIR 1999 Supreme Court 1047. AIR 1999 Supreme Court 1047. If suppose the limitation expires and thereafter he makes an acknowledgement, then that will not save limitation. If 3 years is over, 6 months later he makes an acknowledgement. See, we must not confuse it with past liabilities, payment of past liability. if a fresh document is executed for payment of past liability, if you are the plaintiff is entitled to file a suit on time barred debts. But this is with respect to acknowledgement of a time barred. You cannot acknowledge a debt which is barred. But you can always come to pay the debt which was already in for which there was already a debt. That is not barred. Section 25(3) of the Contract Act. When we see Section 25(3) of the Contract Act, time barred debt the plaintiff is entitled to recover. We have to relate it with Section 59 and 60 of the Contract Act. See what happens if I have given the same defendant three different amounts: 1 lakh, 1 lakh, 1 lakh, 2 lakh, and 3 lakhs. Three different periods. The first 1 lakh is time bar on a particular promissory note. The defendant on the 4th year pays that money. The plaintiff can adjust that payment for the first debt. He himself, if he does not specify to which debt it must be accepted, if the defendant does not specify to which debt it should be adjusted, the plaintiff can take advantage of it and adjust it with the past debt, even though it is time barred. Section 58, 59, and 60. It relates to the time period if it is specified and if it is not specified. Now, Section 25(3), time barred debt. Payment can be adjusted towards that, or a new lease of life can be taken with respect to time barred debt. But so far as acknowledgement of liability, the liability should be acknowledged before the time expires. That is 2017 1 MWN. 2017 1 MWN 479. 2017 1 MWN 479. It should be before limitation period. Another 2008 4 Law Weekly 331. 2008 4 Law Weekly 331. See, another case law. 2009 3 CTC 650. It is more interesting. 2009 4 CTC 3 CTC 650. What this says? You need not acknowledge to the concerned plaintiff itself, showing it in the balance sheet. That amounts to sufficient acknowledgement. Company showing in the balance sheet that it owes money to the particular person, then it amounts to sufficient acknowledgement within that period of time. Now, Section 19, acknowledgement by payment of money. If you pay some money, then the limitation period automatically gets extended. The difference between 18 and 19 is only one thing. In 18, the person writes it. In 19, the defendant concerned, the borrower concerned, pays it. That is, the previous citation is 2017 1 MWN 479. 2008 4 Law Weekly 331. 2009 3 CTC 650. 2009 3 CTC 650. So this is the only distinction that we have to see, 18 and 19. Here also the payment must be made before the time expires. Now, you take the case of payment during mortgage. If the land is in the possession of the mortgage, what happens? If the mortgagee takes some money or rent from that period, it is payment. It is to be recognized as payment under Section 19. The time period starts afresh. 20, payment, acknowledgement of payment by person authorized. 18 and 19 also says that if a person authorized, if he makes some acknowledgement or if he makes some payment, then that is valid. Section 20, payment made by lawful guardian, payment made by trustees, payment made by managers, all are accounted. Exception is partners. That is, they cannot come under person authorized. He himself, that is joint contractors, executors and mortgagees. They are exception to Section 20. Now, adding parties. Section 21, adding parties. If a new person is implemented, what happens? What is the effect of it? It is deemed to be, the suit is deemed to be instituted when he was made a party. This applies to legal has also. That is exception to 21. Suit can be filed only against the defendant. If you wanted to prosecute some other person, want to implicate the person, that person. But if a legal error is implicated, section it operates as an exception to 21. Transposition of parties is an exception to 21. AIR 2000 Supreme Court 172. AIR 2000 Supreme Court 170. Generally, limitation starts running from against the person only from the date when he is added. If suppose the court says it will have a retrospective effect, then he is deemed to be implemented from the date of the suit. AIR 2001, AIR 2001, 1185, AIR 2001, 1185. Now, section 22 deals with continuous breach. We have already seen. That is, the limitation continues on every breach. On every breach, the limitation continues. 23. Compensation only on account of legal injury. See, we would have come across the legal principle, injuria sine damnum, damnum sine injuria. Injuria sine damnum. There is a legal injury without a damage. Damnum sine injuria. There is a damage without a legal injury. Which one, the plaintiff, which one he can claim? Whether injuria sine damnum or damnum sine injuria. That is, injuria sine damnum. There is a legal injury. Injury means legal injury without a damage. I will relate it with an example. There is a damage without a legal injury. See, you are having a shop. Some other person opens another shop and sells the product, same products. Now your customers goes to the next shop. There is a damage, but you cannot call a legal injury. You cannot file a suit to restrain the person from opening another shop, similar to the trade. Stationery shop, another stationery shop. Ice cream shop, another ice cream shop. Cloth shop, again another cloth merchant. So you may suffer some damage because of some other act of your of the another person. You cannot claim compensation. So there must be a legal injury. Even if there is no legal injury damage, if there is legal injury, you can file compensation. That is section 23. Now, how are you calculating the time period? How? Yeah, on what basis? It is always calculated on English calendar. Section 24. Time limit starts running as per English calendar. Section 24. See, these three chapters, these three parts, part 1, part 2, part 3, we have discussed about the definitions. Section 3, the exceptions are section 4 to 24. We have covered section 4 to 24. 4 is court holidays. 5 section sufficient cause. 6, 7 the legal disabilities. Running of time, section 9. And then 12, 13, 14, it deals about obtaining certificate copies, exclusion of time, extension of time. Section 18, 19. Limitation continues without rest. Breach of contract. This is with respect to part 3. Now, we are on to the last portion of the limitation. Part 4. This prescribes some right. It gives, it says acquisition of ownership by possession. Just by mere possession, you become an owner. In all suits, we file a suit on the basis of title. This particular section provides a right on the basis of possession. Possession, adverse possession. These possessory rights can be with respect to various things. One, mere possession. Easementary rights. Exercising easementary right for over and above 20 years. So where the limitation starts? 20 years plus 2 years. Within another 2 years, the person has to file the suit. Else, he is barred. Adverse possession, 12 years. Article 64, 65. Regarding that, we may have to have a separate session. The other provision is that the government has given 30 years, the suit against government 30 years. So, these three sections deals with a right available to a person on the mere possession of certain land or incidents attached to the land like easement. These are all the three sections. Now, I wish to point out some of the case laws arising in different angles. Whether certain things will arrest limitation. In what context the one right gives rise to another right. Permissive possession, adverse possession. All these aspects, just I wish to give some 10 case laws on different issues, and I wish to conclude the session. It is almost going to be 8 o'clock. Now, section 29. See, Arbitration Act prescribes some limitation period. Tamil Nadu Buildings Lease and Rent Control Act prescribes some limitation period. Whether can you fall upon to the Limitation Act or to those special enactments? Limitations prescribed under those special enactments will prevail over this general law. Arbitration Act. See, 2023 CTC 510. It prescribes a specific period of limitation under section 37 for appeals. You have to invoke only that limitation and not the general limitation. Chit Funds Act. It specifies different limitation. 2019 5 CTC 179. 2019 5 CTC 179. That act has to be followed. Now, it applies to IBCs. 2019 5 CTC 622. Limitation law applies to IBCs. 2019 5 CTC 622. No limitation is prescribed for Order 9 Rule 7 applications. You can file an application anytime. 2010 7 MLJ. 2010 7 MLJ 802. Suppose what happens if you file the appeals, second appeals, filing only the certificate copies of the appellate court without filing the degree and judgment of the trial court. What happens? That time is excluded. 2011 5 Law Weekly, 2011 5 Law Weekly 268. 2011 5 Law Weekly 268. Partition suits. Partition suits, no time limit. No time limit for applying final degree. 2007 AIR 2007 Supreme Court 1077. AIR 2007 Supreme Court 1077. EP can be filed only on final degree, not on preliminary degree. 2012 3 SEC 548. 2012 3 SEC 548. Suppose if you file a partition suit and get it dismissed for default, is the same plaintiff entitled to file a second partition suit? Yes. That is, Order to Rule 2 will not apply. 2010, 3 CTC. 2010, 3 CTC 385. In partition suits, defendants and plaintiffs are equal. 2012, 6 CTC 286. 2012, 6 CTC 286. Suppose in a case of a specific performance suits, refund of money, 12 years is prescribed, not 3 years. 12 years is prescribed. 2013, 6 CTC, 2013, 6 CTC, 16, page 16. Suppose if you file a suit for injunction, the defendant says disputes title. What happens? You must have to file a suit for declaration. A comprehensive suit can be filed. That particular period of prosecution can be excluded. 2013, 4 CTC, 2013, 4 CTC, page 45. 2013, 4 CTC, page 45. See, when limitation does not protect you. Here is a case. Second marriages. In case of appeal, if suppose a decree has been made, divorce has been granted. After the limitation prescribed under the Marriage Act, the husband or wife enters into a second marriage. Now, the time period is over. The person concerned has not filed the appeal within the time period. The second marriage has been contracted. What happens? That second marriage is valid. The second marriage is valid. 1996, that is, sorry, 2020, 2020, 2 CTC, 2020, 2 CTC, 359. 2020, 2 CTC, 359. The second marriage is not a void marriage. In that case, delay cannot be condoned. Suppose if there is no sufficient cause or if there is no fraud by the concerned party. 2019, 6 CTC, 2019, 6 CTC, 304. Here also second marriage was performed. Now what happens in case of a counterclaim? Counterclaim had to be filed along with the written statement, but a leverage is granted till filing of the issue or till framing of the issues. 2020, 2 CTC, 2020, 2 CTC, 437, Supreme Court. 2020, 420, 2 CTC, 437. Now, if there is a fraud on court sale, 2021 CTC, 2021 CTC 757, 2021 CTC 757. See, fraud vitiates all Solomon proceedings. That is the rule. Fraud vitiates all Solomon proceedings. 1994 Supreme Court, AIR 1994 Supreme Court 853. AIR 1994 Supreme Court 853 and the last judgment 2003 8 SCC 319. 2003 8 SCC 319. But here the fraud should be pleaded, fraud should be made specific, and it should be pleaded and be proved. 2011 4 CTC 640. 2011 4 CTC 640. Now, with this, I wish to conclude the session. And one aspect I just wanted to point out, that is with respect to schedules. Schedules, I have given an indication that we can easily remember the schedules. Suits are of various types. Suits, appeals, and applications. Limitation period. Suits, there are 10 different formats are given under the schedule. It has 10 divisions. In suits, the limitation period starts from 1 year to 30 years. suits for accounts, suit for movable properties, suits on contracts, suits on declarations, suit to set aside an instrument, suit to cancel the decree. Different time limits are prescribed for suits in the same schedule. 10 categories of suits are prescribed. And for appeals, limitation period is prescribed in days and in months. For applications, limitation period is prescribed in days and in years. In some cases, limitation prescribed for from 10 days to 90 days. We have to go through all the things in schedules. Limitation for appeals in high courts and subordinate courts, that has been prescribed. So, we have to take note of the schedules also. With the last thing, in some type of cases, limitations are not prescribed at all. Continuing offenses. It is not the economic offenses. No time limit is prescribed. So the court can take for lifetime the capital punishments. No time limit is prescribed, even though cognizance can be taken within a particular period of time. So with this, I wish to conclude. I have taken on the meanings and principles, the objects, the maxims, the definitions, the exclusions, the extensions, continuity in limitations, what would happen in case of legal disabilities. In case of appeals, it is between 30 to 90 days, madam. 30 days in case of subordinate judiciary. In case of appeals, it is 90 days. And the adverse possession. So I thank one and all. Thank you so much for this opportunity, Adilakshmi madam, and all the coordinators also, and all the participants. Thank you so much. Thank you so much.